So just at a high level, AI is expanding the number of ways companies can both collect and process biometric data. And then plaintiffs are using that expansion to push biometric claims into more and more contexts. So we'll discuss litigation trends, look at a few case studies to see what worked, what didn't work, and finish with a practical defense strategy. Ben mentioned at the very beginning the Illinois Biometric Information Privacy Act, BIPA. This is the legal foundation for this section. BIPA was passed in 2008, but it's still the main statute everyone thinks about in this space. It sets standards for how companies handle Illinois consumers' biometric information, and it prohibits selling or otherwise profiting off of that information. It provides categories for what counts as covered biometric data. You can see those categories on the right. And these cases will often turn on whether the challenge data is actually biometric data as defined under the statute. So most of these biometric AI cases fall under a couple of categories. The facial and voice recognition AI cases are fairly self-explanatory. The behavioral analysis and performance monitoring is interesting. The image on the right is actually from the complaint in a case called Konow v. Brinks. This was a 2024 Northern District of Illinois case, and it involved smart drive technology that would scan drivers' faces, and then it would conduct facial mapping to identify driver risks and dangerous driving behavior, such as drowsiness. The next category is surveillance and monitoring. This is a slightly different flavor because it doesn't necessarily infer anything about behavior. Think sort of checking in at the gym with your face or clocking into work, that sort of thing. And then finally, we're seeing a lot of litigation about virtual try-on software that will capture facial geometry, usually for sunglasses. I think Rayban and Warby Parker both have this. So before we dive into specific cases, I just want to note that BIPA was making such a splash with high damages numbers that there was an August 2024 amendment to limit recovery to at most one recovery per person when the collection is done by the same method. So this stops plaintiffs from trying to count every single scan or every interaction as a separate violation. The amendment also expands the meaning of written release to include an electronic signature, which is great news for defendants, gives a clearer path to document consent. So with that, let's turn to two cases to see what worked at two different stages in the case life cycle. Starting off with a motion to dismiss in GT v. Samsung. Samsung devices come pre-installed with a gallery application, which Samsung designs and owns. The app uses proprietary facial recognition technology to scan images and then search for faces. If the app detects a face, it will analyze the face's unique facial geometry to then create a face template. The result is that pictures with specific people's faces are stacked together on the app. So what can we learn here? The motion to dismiss successfully argued 1, no possession. BIPA section 15A applies only to private entities in possession of biometrics. So the court acknowledged that Samsung controls the app and the technology, but it still found that it doesn't necessarily follow that this control gives Samsung dominion over the biometrics generated from this app, and that the plaintiffs did not allege that Samsung actually receives or even could receive such data. Number 2, no collection. Section 15B requires the plaintiff to allege that the defendant collects, captures, or otherwise obtains a person's biometrics. Here, Samsung successfully argued, and the court found that plaintiffs didn't actually allege that Samsung receives the data the app accumulates, or that Samsung had access to it, or that Samsung even took any active step in gaining control over the biometrics, which doomed this 15B claim. Finally, Samsung argued successfully that the information wasn't even subject to BIPA. We looked at those covered categories on an earlier slide, and the allegation here was only that the app groups unidentified faces together, and then it's the user who has the option to add names to the faces. So this was therefore not biometric data under BIPA because it wasn't capable of identifying an individual. Similar facts and similar approach in Zelmer, but this time on a motion for summary judgment. Facebook uses a similar face signatures photo suggestion technology where Facebook will analyze whether the user's Facebook friends are in the user's photo and then suggest that the user will tag the friend in that photo. So here Meta used a project manager's declaration as technical evidence that these face signatures that Facebook uses, again, couldn't actually identify individuals. The face signatures were just strings of numbers representing an image of a face, did not reveal geometric information, could not be reverse engineered, and neither saved nor stored after the final stage of the tag suggestions process. As a result, this didn't count as biometric identification information as defined by BIPA, and the Ninth Circuit affirmed the grant of summary judgment. So here, I just want to briefly note that BIPA gets the most attention by far still, but it's definitely not the only biometric game in town these days. Texas has the Capture or Use of Biometric Identifier Act, QB, which requires consent for capture of biometric identifiers for a commercial purpose. Note here, though, that the Texas Attorney General has exclusive authority to enforce and hand out civil penalties. Washington State has the My Health, My Data Act, which took effect in 2024. This one focuses just on consumer health data, including biometric data, and it has both Attorney General enforcement and a private right of action. New York City also has a local law to regulate collection and use of biometric data within the city. This was enacted 2021. It applies to every commercial establishment within the city, and businesses must place a clear notice right when you walk in, notifying customers that their biometric information is being collected. The businesses also can't sell or otherwise profit from this information, and there is a private right of action available with statutory damages. So the point here is just that the biometric risk is spreading across jurisdictions, and the enforcement mechanisms and the exposure all differ. So as far as how to successfully litigate these cases, you'll want to consider a few things. As an initial matter, we should always look to see if there's an option to enforce an arbitration clause, both to get the case just out of court and then to also defeat class leverage. Next, extraterritoriality. The idea here is to build facts showing that the conduct didn't occur primarily and substantially in the relevant geographic region. The exact requirements are going to differ for each statute, but for BIPA in particular, this argument can be really powerful. There was a 2024 Northern District of California case, Vance v. Google, where Google got a BIPA complaint dismissed because the plaintiffs did not allege that Google ever interacted with them or any other person or entity in Illinois to obtain the data set at issue. Next, consent. The business needs to inform the subject in writing that the biometric information is being collected and for what purpose, and then a written release is required. So a lot of these cases will turn on whether the company gave clear disclosures, which means defendants will want to look closely at agreements, notices, acknowledgments, written policies, and any sort of consent flow. Finally, you always want to consider attacking the plaintiff's premise that the information is actually biometric information covered under any of these statutes. This is often the core fight, as we talked about earlier, both in the Samsung and the Meta face tagging cases.